So what we're going to cover today is the effect of Me Too in the workplace. You've all heard of Me Too. It's been in the news. It has caused a lot of consternation. It's probably changed the nature of the way you do things in your workplace. So it's an important issue to talk about. We're going to talk about the subject of workplace bullying. A lot of people think that workplace bullying is covered by, federal law. It's not. In some cases, but it is covered by state law in a number of places. We're going to talk about the difference between harassment and bullying. We're going to talk about the issue of religious accommodation because that's one of the areas under the EEOC that frequently gets overlooked and is frequently complained about. And then we're going to talk about the subject of dealing with Family Medical Leave Act abuse and how you can perhaps control some of the issues that you see on a day-to-day basis if you are having to deal with family medical leave. So with that, let's go ahead and get started. With this disclaimer here, I am not an attorney. The information I am providing to you in this webinar is not intended to be legal advice. It's HR advice. It is to give you some guidance. If you have a particular situation where it would be to your best advantage to consult legal counsel, I encourage you to do so. I'm hoping to give you some advice on that will make that conversation with your legal counsel a little bit more relevant. Me Too. That started a good number of years ago, or a certain number of years ago, mostly in show business. And it was names like Harvey Weinstein and Bill Cosby that were associated with that the abuses that those men were accused of made for good press and certainly made everybody appalled at what they were accused of doing. I'm not saying whether they're guilty or not. That is not for me to decide. It is for the courts to decide. But the press, for the most part, has certainly indicated that they are guilty of many of the accusations that were brought against them, and it highlighted to the rest of us the potential abuse that can occur in those kind of positions. Now, those are two men that had a lot of power. Those are two men that had a lot of ability to control people's lives, and as a result of that, they took advantage, or allegedly took advantage of their positions. The result of that for the rest of us is the fact that $47.5 million has been recovered for victims of that harassment, and that continues to go on. More women have felt emboldened to file their complaints, and we are seeing that in the workplace. It has changed the way we do things in the workplace. People have become more conscious about it. People in HR have become more conscious of it, though they should have been conscious of it to begin with. Leadership in various companies has certainly become more aware of it and aware of the emotionality that goes with those claims and that they need to do something about that. And as a result of that, we're just seeing heightened awareness in the workplace about sexual harassment. It is covered by the EEOC. It's part of the Civil Rights Act of 1964. Sex discrimination includes sexual harassment, and companies can be found at fault for that. Now, there is a big difference between what was going on in show business and what is going on in the workplace today. Me Too was often focused on harassment that had occurred years in the past. Women were coming forward and talking about what Harvey Weinstein had done 10 years ago and with Bill Cosby 10 years ago. And that is, unfortunately, not something that is going to be applicable to the workplace. You can't file a complaint from something that occurred 10 years ago. In the workplace, the complaint has to have occurred within 180 days of the last incident of harassment. That's what is written into the law, and The law says that if you have an incident of harassment and you take more than 180 days to complain about that since the last incident, then your case is not going to get heard. Now, there are some states that require that you file with a state agency, and in those states you're actually given 300 days before you your statute of limitations is up with the EEOC. So you got to file state and then you got to file the EEOC. But in the states where that does not occur, you have 180 days to go down and make your claim of harassment. Now, we in HR have an obligation, a legal obligation, that when somebody comes to us, we are required to investigate we're required to investigate that claim of harassment, and you can be found at fault for not following up on that claim. So when you are, what's needed to protect the company in terms of sexual harassment is a good sexual harassment policy. All of you should have that. If you don't have one in place, you need to make sure that you go and seek out your attorney, or you seek the advice of the Society for Human Resource Management, and you can get examples of what a good policy is. It is one that covers, what it defines the two forms of sexual harassment. It defines what the reaction is supposed to be. It defines it defines the process that somebody's supposed to go through in order to be able to put their claim forward. Who they need to complain to. You need to have a good policy that dictates who somebody should go and make their complaint to. Typically, it is you complain to your manager, but in many cases, the manager is the one that is accused of harassment, so you can't do anything about that. So you need to have an outlet for them, and that's typically going to human resources, but not always. It could be that you end up having to go to an ombudsman. It could be that you go to somebody else in management. It could be any number of things, and you need to think about that in your particular situation of where somebody's going to be able to go to file a complaint. And the SHRM policy that's available on their website is a good way to get an idea of what needs to be done. You need to provide training to both your managers and to your employees. And in fact, several states now require that sexual harassment training be done on an annual basis for all the employees and for all the supervisors. In that particular case, you need to be training people on how to identify sexual harassment, what to do if they feel that they are receiving sexual harassment. They need to distinguish between the quid pro quo or this for that kind of sexual harassment and versus the harassment of an uncomfortable workplace or a hostile workplace. You need to make sure that you're not saying things like Ernst & Young did, that telling that their employees that it's not that big of a deal, and that it was a very bad. They downplayed the importance of sexual harassment in their workplace, and they ended up getting in a lot of trouble for that. You need to have a policy, and you need to have a procedure that brings this to leadership's attention so that they're aware of what's going on. You need to promptly investigate any complaint of harassment, and then you need to take action on the findings of that investigation. When you're doing an investigation, there are a number of things that are needed to do that. Number one, you need to have a well-trained investigator, and not every HR person is a well-trained investigator. So one of the things that you in HR or if you're in management that is given the responsibility for doing this investigation, you have to take a look at yourself and say, am I far enough away from this situation that I'm going to be perceived as being neutral in this investigation? If I am being perceived as being too close to the person who has been accused of the harassment, then in that particular case, I will not be a neutral investigator, and you need to go to your law firm and you need to say, I need a neutral investigator. Now, your law firm is not going to be able to do that for you. They're going to have to be in the position to defend you. They're going to have to say, we can't do that, but they will go find a third-party investigator that can come in and do that investigation for you. It needs to be done promptly. I was called in to do an investigation, but unfortunately, when I went in and talked to the company, I was not going to be available for 2 weeks to be able to do that investigation, and they understood that they needed to do something promptly, both for legal ramifications and also for to show their employees that they are taking the action necessary. And so they ended up having to get somebody else to do that. And I didn't have any problem with that. That was, I totally understood that need for that prompt action. That's something that the EEOC calls for, that you need to have it investigated, and you need to do so promptly. Now, one of the other things as you go through and do this investigation, what you may find is that indeed somebody appears to be guilty of what they are accused of, or there's not enough evidence that anybody is, that anything really occurred, and you need to document those findings. You need to react to people who are involved with that. You need to let them know, the accuser know of what your findings were. And if you're taking action, they need to know what that action is. Or you may tell them that you found nothing that, it really was going to allow you to make a decision in this particular case. And so you were noting this in the file and you were not going to do anything about it. But one of the things you have to be very careful of is making sure that managers or supervisors or other employees who have been accused of harassment, they end up not reacting to that accusation and engaging in what could be perceived as retaliation. In many cases, retaliation could actually be perceived to wait for a period of time. As an example, you have somebody who accuses a manager of retaliation. The finding is that really apparently nothing occurred that you and HR as an investigator could determine, and so everybody was put on notice, but nothing was done. 6 months later, a promotion opportunity comes up in that same department, and the person who made the accusation applies for that particular promotion, but doesn't get it. It's given to somebody else who was deemed to be a better fit for that particular management situation. In that particular case, the person who was turned down, who had made the accusation, in all likelihood is going to perceive having been turned down as an act of retaliation on the part of the manager for having accused them in the first place. And the manager has to be very careful that they make a reasoned business decision on why they're turning that person down. HR has to make sure that they are making a reasoned business decision, that the person that got the promotion was indeed by performance more qualified for that position. You've got to make sure that that person is not being turned down because of what they had done in the past. So you've got to be very, very careful to avoid retaliation. Retaliation is actually the most frequent complaint that is filed to the EEOC on discrimination, and you've got to make sure that you're very careful to avoid getting accused of being retaliatory in your decision making. So a lot goes into that, and I could do an entire hour. I could actually do several hours on just sexual harassment. We're not we don't have the time to do that. We've got other things to talk about. But I hope that I have given you some idea of what you can do. Now, we just passed St. Valentine's Day a couple days ago, and in many cases, you become aware of dating relationships in the workplace. Some people try to control relationships in the workplace by having them, those involved sign what have been termed to be love contracts, where they sign a document that says that the relationship is consensual. You and HR still have to pay attention to it, because if that relationship goes sour, you can be put in a position of having to deal with a sexual harassment situation. If one party no longer wants to be involved and the other party wants to continue with it, you have to be aware that situation will be one that could be rife for sexual harassment. But I want to tell you that, some companies try to take care of that by having people sign this document that is consensual, and more likely than not, it doesn't work. It doesn't, free you from any responsibility. It doesn't free you from that relationship going sour and impacting the working relationship between those two parties. I will say, as a human resources manager that's been in the business for 40 years, that anytime you have a relationship develop between a manager and supervisor and a subordinate, you need to watch that very carefully. And as a matter of fact, I've worked in companies where we have actually forbidden those relationships. They unfortunately go on in secret, but if anytime you get a hint like that, you need to watch those very carefully, and you need to make sure that it's not affecting the working relationship, and then as soon as it starts affecting the working relationship, that you pay attention to it, you investigate it, you make the changes that are necessary. And you have to realize that even if the two people that are involved in that relationship are very good, control it very well, and they're very responsible about dealing with it, that you could actually get a sexual harassment case out of one of those love contracts from somebody that is outside of that relationship. You could have somebody who is not romantically enrolled with a manager who perceives that the person is getting ahead in work, is getting promotions, getting increases because of the relationship they have with that manager. And as a result of the fact that they're not in a relationship with that manager, they feel that they are being discriminated against, and they can file a sexual harassment case based upon the fact that they don't have a relationship with a manager, and they feel that they're suffering harm as a result of the relationship that that manager has with somebody else. So I have never been a big fan of relationships at work. I have never seen one that has, in my working time, that has worked well. At some point, they cause a lot of divisiveness. And I even worked in a place where we had 5 vice presidents who all ended up having an affair with their secretary, divorced their wife, and ended up marrying their secretary. And that causes a lot of strife. It causes a lot of heartache in the workplace. So those romantic relationships can be very, very difficult. And I wish you success if you're having to deal with one. Today, the definition or the subject is bullying is very much in the news, as is sexual harassment, but bullying is too. And bullying has even gotten to the point that it affects our children, it affects things that are going on in school, it certainly affects our workplace. I've had clients of mine who, the people that I'm working with, the HR people that I'm working with, have talked to me about bullying, the fact that I had an HR manager who felt that she was being bullied by her boss. It was not a sexual harassment situation. It was the boss was just not a very nice person, and as a result of that, it made this person feel powerless to be able to respond because of the power distance between her and the boss. Bullying is generally an unwelcome behavior that occurs over a period of time. It's meant to harm somebody who feels powerless. It is all about power. It's all about abuse. And it does not have to be a boss to subordinate relationship, though it quite often is. It can be other people in the organization who are, worker to worker. It can be subordinate to subordinate. It can be somebody from outside the organization that is bullying somebody. And it doesn't have to be face-to-face. It could be written. It could be by phone. It could be by electronics. It could be on social media. In fact, you hear that all the time. I was looking at something today on social media where, there's a well-known singer that has felt bullied by part of her audience because of her appearance. You get people who are being fat-shamed all the time. You get mothers who are being shamed for being, nursing in public. You get people who gain weight or who are ill, and they're all being shamed by people on social media. Well, that's all a form of bullying. That is somebody who is trying to exercise the power that they have over that person, or the perceived power that they have over that person, by being mean or rude or or worse. And it is, part of, and I have in my slide here, being ignored is a form of bullying. That's one of the things that you can do in the workplace to bully somebody, is that you do not include them in meetings. You do not include them in conversations. That you have somebody that sits over in the corner, nobody ever interacts with them for some reason or another. That's a form of bullying. That is somebody that is trying to make that person's life uncomfortable. Now, there is no federal bullying law, and so you as an HR person cannot say, I've got policy on, that's complying with the bullying aspects of our organization. There is no federal law. Now, there are some state laws. I think California has already passed a bullying law, and so in the various venues that you're in, you do need to be paying attention to what local laws and what local regulations have been passed. And you do need to be aware that if there is a law that has been introduced into Congress, into the House of Representatives. It has not gone to the Senate yet, but it's been, and it's in committee discussions. But there is an attempt right now with the current Congress, with the current House, to introduce an anti-bullying statute into federal law. And I'm not sure where that's going to go. In many cases, many of the laws that we have dealt with have come about out of social movements. If there's a big enough social push for introducing a bullying law into the EEOC, making it a protected category, then we may see that. But as of yet, that doesn't occur. But it has occurred in a number of states. It is occurring in a number of cities. So you need to pay attention to the jurisdiction that you're in. Bullying does become illegal if the bullying that somebody is directing towards somebody else is based upon one of their protected categories. So if you have somebody that is bullying on the basis of somebody's religion or their race or their age or their sexual preference or their some other related category like that, at that particular point, it does become a violation of the EEOC, and the person could complain on the basis of their protected category being used against them, and as a result of that, you then in HR will have an EEOC case that you need to be aware of. So pay attention to that. Make sure that if somebody is bullying, and if they're doing it on the basis of, you know, the old person in the office is being bullied because he or she is too old, or somebody's being bullied because of their religion, then you've got an EEOC case, and it goes beyond bullying. It's now into harassment or discrimination, depending upon what is happening. So be guarded with that. There are 29 states that have anti-bullying laws. Most of them are focused on schools. Bullying happens in the school quite a bit. I talk about that in one of my classes where, we talk about the fact that schools, students can be bullied by their classmates, that not fitting in and not engaging in behavior, or studying too hard, or being perceived as being a brown noser, are all areas that can be subjects of bullying. The specific behaviors can include teasing, threats, intimidation, stalking, harassment, physical violence, theft, public humiliation. All of those can be perceived as being bullying, and in many states those will violate the state laws about doing that in school, and we can take that as a perception of what our workplaces. Now, what occurs in high school, we will see in many workplaces as well. You have social groups where somebody doesn't fit in. You have social works where somebody works a little bit harder than somebody else, and that's not perceived as being a good thing. That's perceived as being a brown nosing. So those of you that have, systems or plans where you get an employee of the month, depending upon what social group that employee of the month is associated with, they may then get bullied for being a good employee. Their picture on the wall gets defaced, their car in the parking spot gets keyed, and as a result of that, they don't want that award. They do not want to be recognized for their hard work, because they know that they may end up being bullied by a social group that they're associated in the workplace. So you do need to be aware that that's a possibility. You do need to be aware of what you need to do to potentially control that. There is a bill in Congress right now called the Healthy Workplace Bill that will deal with and institute bullying laws. So be aware of where that goes. Pay attention to what's happening with your Chamber of Commerce and the legislative process, or with SHRM, or other various HR groups that will keep you updated on what's happening with that particular bill. Like I said, not all workplace bullies are bosses. Co-workers can be bullies too, and it could be one-on-one aggressive behavior, or it could be that they are excluding the individual from information, excluding people from meetings, of not tying them into the informational network that is necessary for them to get their job done. That can all be perceived as being bullying, and you certainly, the manager needs to be aware of that, HR needs to be aware of that, the employees need to be open to coming to HR and telling them that this is what's occurring to me and I need some help in getting over this. I have this up there: competent managers manage, bad managers bully, and I think we've all probably seen that. But one thing you need to be aware of is that sometimes younger employees in particular will think that they are being bullied, where in reality they're just being managed tough. A manager that is trying to get somebody to do some work, a manager that is trying to get somebody to be a better employee, improve their performance, improve their attendance, may be perceived as being a bully, and in reality they're not. So in some cases it's a fine line between that tough love and being a bully. So that's a judgment value that you're going to have to make on whether that manager is bullying or whether that person is really just trying to recover that employee. There is no necessarily, step-by-step assessment that you can make because it's going to be dependent upon the relationship between those individuals, and it's going to be dependent upon the history of the people that are involved with this. You may know that you have a manager who is a tough person to work for, but everybody that works for her is happy that they have gone through this in the past. You introduce a new employee into that mix who is in their lifetime been bullied, who is come from a situation where they were not as welcome, where they were not as accepted, and as a result of that, they now perceive this situation of working for this tough manager to be a bullying situation. And like I said, that's a judgment call that you all are going to have to make that comes from knowing the situation, knowing the people, having conversations, working that out. So that's about the best guidance I can give you on that particular situation. One of the things that you, in dealing with your employees and teaching them about how they can help stop bullying, is that if they really feel that they are being bullied, number one, they've told you about it, so they need to make sure that they are sharing with HR, that HR is open to having those discussions. They need to record the incident, and record, I don't necessarily mean turn a tape recorder on or record something electronically on their phone. They just need to record what occurred, when it occurred, who was involved, what was said. And if they feel that they are being bullied, that they need to tell the bully to stop. And if they can't get that done, then they need to come back to HR and say, hey, I need your help with this. And HR needs to be willing to deal with that and help that employee with that particular situation. HR should investigate, should find out what this person is being bullied about to make sure that they're not being bullied about something in a protected category, that they're not being bullied about age or race or sex or their gender preference or anything like that, because that's going to get you in trouble with the EEOC. So it does warrant investigation on the part of HR. It does help if you have a policy against bullying. You can identify in your organization what you consider to be bullying. You can, again, go to the Society for Human Resource Management and get a definition of what that bullying is, what a policy would look like. If you hear a report of bullying, somebody has seen that occur, you should investigate. But no action should be taken just on allegations. You need to investigate, you need to find out what the situation, and then make a determination on what you are going to do and how you're going to talk to the parties. It may be that you do have to talk to a manager about the fact that they're being too pointed on some of the things that they're doing and that they're bordering on harassment. But in other cases, that conversation with that manager, you could just find that they are, just engaging in that tough love and to try to improve an employee. But all reports that you hear from individuals that are the objects of bullying, or people that are co-workers with them that are, or observers of that bullying, all of that should be taken seriously, and action should be taken to halt that. The EEOC, just so you know, does have a program on what they call civility training, which is designed to help cut down on bullying in the workplace. You can go visit their website and take a look at what that civility training involves. You can invite them into your workplace to conduct that kind of training, or you can model your training on that particular training. But you need to know, be aware that it is designed to cut down on instances of bullying and that you are making a stance against that in your workplace. All right, that's the bullying aspect. Now, one of these areas that is quite often is object of both discrimination and bullying is in religious accommodation. Most of us are aware that in racial harassment or sexual harassment or what we're supposed to do, not all of us really deal with religious accommodation, and it will go up and down based upon events that are happening in the world. It's protected by the EEOC, and you have to realize that somebody that is claiming a need for religious accommodation does not just have to be ascribing to traditional organized religions. That it covers anybody who has sincerely held religious beliefs or ethical or moral beliefs that are, what's a good way to say this, are not the typical church beliefs. So we all know that, Catholic, Protestant, Muslim, Hindu, or other religions like that, but you could have Rastafarianism. You could have somebody who belongs to a small sect who has most of us would not recognize that. Most of us would not even have ever heard of that. I had one client who had an employee who, was claiming that they belonged to a small group that did not allow them to practice work on Saturdays, and they wanted out of coming to a Saturday meeting because of that religious belief. The person, the human resources manager, general manager of the place, did not feel that that was truly a sincerely held religious belief. They did not allow that, actually ended up terminating the person. The person went to the EEOC, and they were able to convince that they had converted, and that they were able to convince the EEOC that they had converted, and that belief was sincerely held, and the company was admonished and ended up having to pay a fine for having violated that person's sincerely held religious beliefs. So you've got to be very careful about saying, man, I've never heard of that, and that can't obviously be a real thing. You've got to investigate. You have to understand. You have to talk to the people and understand what their belief is, and then for the most part, give them credit for doing that. Now, in the accommodation part of this, you are required to accommodate their belief unless it causes you more than minimal burden to your operation. So accommodations for religion would include things like flexible scheduling, voluntarily shift substitutions, switching jobs, switching, reassignments, modification to the workplace or the procedures, allowing somebody to wear a garment, allowing somebody some prayer time, allowing somebody to not work that particular day, and you've got to, if you're going to claim that it is very disruptive, you're going to have the business case that shows the cost and the disruption that is involved with you having to make that accommodation, and that if it is very disruptive or it's very costly, then you can turn the person down. Just realize that you're probably going to end up with them filing a complaint with the EEOC against you for you not having talked to them about that. You are required to engage in a documented, interactive discussions on the needed accommodations for that particular religious belief. Now, this interactive discussion, documented interactive discussion, is actually goes with all of the protected categories that are covered by the EEOC. It's particularly important when you're talking with people about disabilities and why they need to have an accommodation for the disability, but it's just as important if you're talking to people about needing an accommodation for their religious belief. You have to have a discussion with them, document that discussion, understand why they need that. If it's a belief that you're not really familiar with, becoming familiar with that, documenting all that, and then making your decision and telling the employee that you will accept and offer them that accommodation, or it is something that is not something that you can accommodate, and as a result, because you can't accommodate it, they're no longer able to perform the essential functions of their job, which means that you now are in a position to take action against them by terminating their employment. I wouldn't get to that quick. I would get to that after a lot of interactive discussion, a lot of consideration of what the accommodations are or what they could be, finding one that's acceptable, and then determining whether it is disruptive or whether it is too expensive. So be very guarded about quickly making that decision. Undue hardship in that accommodation effort means, is it too costly? Does it compromise safety? Does it decrease efficiency? Does it infringe on the rights of other employees? Or does it require other employees to do more than their share of hazardous or burdensome work? Just because somebody doesn't want to do the work doesn't mean that they can claim a religious accommodation. And for that, there really truly has to be something there. And if they're not meeting the standards of this undue hardship, then you're free to make a different decision. How do you respond to a request for an accommodation? Ask what accommodations would be acceptable. Engage in that documented discussion. Document your analysis of the various alternatives. Be flexible in your scheduling. Don't segregate workers who have a need for a religious accommodation. And again, last but not least, avoid any retaliation as a result of them having made that request for an accommodation. And lastly, what we're going to talk about, and we've got 10 tips on this, is we're going to talk about family medical leave abuse. Now, not all of you may have to comply with that. You do if you have 50 or more employees. So I'm hoping most of you are having to listen to this. A good friend of mine and colleague is a fellow by the name of Jeff Nowak, who is a specialist in family medical leave, and he says it, I pay attention to it, but he says that attorneys call the Family Medical Leave Act the Friday, Monday Leave Act, and that just leaves it open for a lot of abuse. And he writes a blog that he talks about all the time, 10 tips that you can use to try to overcome that abuse. And he writes about some horrid stuff. There was a city in the Midwest that their family medical leave was not being controlled that well, and he had a whole group of employees that decided they wanted to go on a cruise, so they all put in for family medical leave, and they went on the cruise together, left the organization missing a lot of people, and that's because the person that was in control of that leave did not handle that very well. So you want to make sure that you're avoiding that kind of abuse. Tip number one from Attorney Nowak is the fact that you need to require that all employees fill out a request for all absences. That if they're going to be out for sickness, they're going to be out for, for a child's absence, they're going to be out for the illness of another family member, that they fill out a request for that. Now you can go to the internet or you can go to SHRM and you can put in family medical leave request forms, and you can get a copy of that if you do not already have one. That will provide you with all the information you need for them taking that absence. But any absence, somebody's going to be out, they're attending a funeral, they're attending, whatever, make sure that all employees are actually filling out a request for whatever absence that they're going to be. You need to then ask them a list of questions. What is the reason? What essential functions can they not perform as a result of what they're having to deal with? Will they be seeing a healthcare provider if it happens to be for their own their own medical condition? It is, have they taken any leave for this illness in the past? And when did they become aware of this condition? Because part of what goes in the family medical leave is the fact that the employee is supposed to let you know at least 30 days in advance, if at all possible, about what their condition is. And you know, obviously accidents and those kinds of things can't be foreseen, but certainly some illnesses can, some treatments can, some pregnancies certainly can be foreseen. And you know, the law does require that they provide as much notice to you, the employer, as possible when dealing with that. Tip number 3 is, he says you need to enforce your call-in procedures. And so if you don't have a call-in procedure, you need to develop one. Again, you can go to SHRM for that. But he says you need to have a minimum of 1 hour before work time, so people just can't not show up and not call in until 2 hours after they were supposed to have been there. Have a specific person to whom they must report. They don't leave a message on the voicemail system. They don't just send a text message, that they have to report to a specific person and hopefully talk to a specific person, and then specify in that call-out procedure what they have to tell you, why they're out, what's involved, who's involved, those kinds of things. Tip number 4 is certify, and there's a form for you to certify the need for that lead. And then if they're going to be out because they are, you know, the law allows them to have up to 12 weeks, that you continue to recertify. And you are allowed to recertify once a month. That means that you can have them, if it's for their personal medical condition, you can have them bring to you on a monthly basis a recertification from their physician for the reason that they are out. There's nothing wrong with asking that, and you can you know, continue to do that for the period of time that they're out. So once a month you can have them recertify. You want to get them to certify far enough in advance that you understand why they're going out, if at all possible. Tip number 5 is follow up with them and seek clarification on the reasons. You know, follow up with them to get recertification. I would follow up with them just to see how they are doing. You never want to fail. You never fail to follow up, because you never know what somebody's doing. You may catch them someplace else. You may catch them doing something that they're supposed to not be doing. You would have, you know, that city that I was talking about would have found out that people were not home as sick, that they were actually out on a boat. Now, there have been cases where people have been able to argue that being at the beach is as good a place to recuperate as it is sitting at home. So if they can produce a certification from their doctor that allows that, then you know, you are in a position of having to decide whether you want to accept that certification from the doctor. But get it clear, follow up, and stay in touch with them. Don't let them just go 12 weeks without having had any contact from you at all. Tip 6 is that, you know, he says that he recommends that you get people to sign a personal certification for the time they took off was for the reason that they stated. You know, if we allow people to lie and get away with it, then many people will take advantage of that. But in many cases, if you ask somebody to actually sign a document that says that they are personally certifying that they have taken the time off for the reason that they have stated to you, in many cases people will opt not to do that. I mean, they will opt not to take the time because they don't really want to be caught in that lie. Tip 7, you can, in many cases, in many jurisdictions, make them stay put. If they have an injury that basically, you know, is going to make them bedridden and they're going to stay at home, check on them. Make sure that they're staying at home, and that if they're going to be leaving that home that they tell you the reason that they're leaving the home. Now, obviously, they'll certainly be going to you know, the doctor's appointment. They may stop for a coffee or something like that on the way, but this will keep people from taking vacation, taking family medical leave to be able to take vacation. And unless they can certify from their doctor that being on the beach is as good a place to recover as being at home, then you can actually make them stay at home. At least one jurisdiction says you can do that. Tip number 8 is follow up on patterns of absences. You know, are they calling out on every Friday? Are they calling, you know, are they taking family medical leave every Monday? Are they, you know, do they have some pattern like that that is identifiable? And make sure that they have you can have their doctor confirm that pattern is necessary for the condition that they're doing. Now, in some cases, it may be. Somebody may be treated for cancer, and they're having to get their chemotherapy on a Friday and then trying to recover over the weekend. But sometimes they're not recovered from that on Monday. So they're only going to work Tuesday, Wednesday, and Thursday because of that medical condition. That's totally allowable. But if you don't confirm that, you're not paying attention to those patterns, you're opening yourself up for abuse, and you're opening yourself up for continued difficulty with that family medical leave situation. Certainly, if somebody's going for a schedule of treatment, you can require them to schedule that treatment around the company operations as much as possible. So talk to them and understand what they're going to be doing, how they're going to be doing it, and have them talk with their doctor and see if, you know, things can be scheduled in the afternoon or things, you know, rather than in the morning. If the doctor can accommodate an afternoon schedule, they may be able to come and work half a day. It all depends upon what the situation is. But you don't know unless you ask. Tip number 10 is make sure that you, on a periodic basis, perform a comprehensive audit on your family medical leave procedures, making sure that you're doing what you're supposed to do, that people are giving you the forms that they're supposed to have, that they are requesting leave on a timely basis, that they are providing feedback to you from their doctors that are necessary. So make sure you're doing the right things by doing a periodic audit on your particular situation. And with that, we've come to the end of this. So in conclusion, I just want to say that sexual harassment is alive and well. Unfortunately, you do need to realize that your employees will have a heightened awareness. Today we're reading about it all the time in the news or on social media, so we can't get away from it. Just be aware that as a result of that, you're going to have employees who have a heightened sensitivity to it. Realize that bullying occurs. Bullying is bad, but there are some differences between bullying and harassment. You have to understand what that is. You need to have your definition of bullying in your workplace. You need to control it. Religious discrimination harassment is a long-standing violation of Title VII of the Civil Rights Act of 1964, but it is one that quite frequently employers are not familiar with on how to deal with it. And then family medical leave, FMLA abuse is rampant, but it can be controlled if you have a good policy and you have good procedures and you have an understanding and are not afraid to address those issues with those employees.